Okay, let's go ahead and get started. Gary, do we still have you on the line?
You got it.
Great. Thank you all for joining us today for this webinar on the Second Chance Act Adult Reentry Planning and Demonstration Project Solicitation. My name is Leah Kane, and I'm with the National Reentry Resource Center. The National Reentry Resource Center is the training and technical assistance provider for all of the Second Chance Act grantees, and we launched in 2009 thanks to support from the Bureau of Justice Assistance in the U.S. Department of Justice. We are very fortunate to be joined today by Dr. Gary Dennis, the Senior Policy Advisor for Corrections with the Bureau of Justice Assistance. But before I turn it over to Dr. Dennis, I'd like to tell you a little bit more about the format for today's webinar. First of all, we want to let you know that today's webinar focuses specifically on the BIA solicitation for adult offender reentry planning and demonstration projects, which came out last Tuesday. Many other Second Chance Act solicitations have been released by BJ and OJJDP, the Office of Juvenile Justice and Delinquency Prevention, that have come out over the course of this past spring. We've hosted webinars and recorded webinars on most, not all, of those solicitations. So if you're interested in applying for a planned demonstration grant to work specifically with youth returned from the juvenile justice facilities, we want to know that a separate solicitation for juvenile planning and demonstration projects will be released soon. And if you are looking for information about any other Second Chance Act programs aside from the adult reentry planning and demonstration projects, please go to the National Reentry Resource Center website, and we'll put up that link in just a minute to find more information about those grant programs. After today's presentation, to ask a question, to submit a question to us, please type the question into the Q&A panel that should appear in the bottom right-hand corner of your screen. Please feel free to ask questions throughout the webinar, and we'll do our best to answer as many questions as possible before the end of today's webinar, about an hour and a half from now. If you encounter any technical or audio problems during this webinar, WebEx technical support is available at 866-229-3239, and I'll put that number up again in just a minute. Unfortunately, there may be some technical issues either on our end or on your end that we won't be able to resolve in this webinar. So for that reason, we're recording today's webinar, and we will be posting that recording on our website before the end of this week. If you've registered for today's webinar, then you'll receive an email notification as soon as that recording is available on our website. So at the end of our technical background for today's webinar, and with that, I'd like to turn it over to Dr. Dennis.
Thank you very much, Leah. Most of you all are familiar with the Second Chance Act, which was enacted became law in April of 2008. For this third year of funding for Second Chance under the FY 2011 Omnibus Appropriations Bill, basically was a continuing resolution for the full year, we received approximately $83 million to fund Second Chance Act programs. The solicitation that we're here to talk about today is for projects to be funded under Section 101, which authorized adult and juvenile demonstration projects, entry projects. Now, Leah mentioned the fact that the Office of Juvenile Justice and Delinquency Prevention had hosted a separate solicitation which mirrors the one we're talking about today for juvenile projects. So this particular solicitation that BJA has posted is only for planning and demonstration grants for adult offenders. This one was released on May 17th, 2011. It's due by, I believe it's midnight, 11:59, June 30th, 2011. The applications have to be filed through grants.gov. The solicitation is open only to state or local government agencies or federally recognized Indian tribes as designated by the Secretary of the Interior. We do, however, encourage private nonprofits, including faith-based organizations, to collaborate and partner with government agencies. If we have any private nonprofit folks, faith-based or not, who are on the webinar today, who are interested in participating in this program, you can't be an applicant nor a fiscal agent. I would encourage you to contact either the State Department of Corrections in your jurisdiction or perhaps the County Department of Corrections and see if those folks may be interested in working with you to develop a reentry program, and that they will allow you to begin to provide services on a pre-release basis by having access to either the prison or jail. So private nonprofits can be collaborators and subcontractors, but only government agencies can actually be the applicant agency. Those of you who are familiar with the Second Chance Act, and I expect that most of you are, will see the next slide. And Lee, I apologize, I forgot to talk about changing slides, but you're probably following along with me.
Doing my best.
I know you are, I'm sorry. The next slide talks about the 10 mandatory requirements. The Second Chance Act in 7101 was very prescriptive when it comes to those elements which must be included in an application for a demonstration project. This is a project to actually implement a program. These 10 items are spelled out on the slide that you have in front of you now, but in a nutshell, the agency should have a reentry strategic plan, a detailed implementation schedule, and supplemental or sustainability plan. They must have had an established reentry task force and demonstrate how that reentry task force has had input into the particular strategic plan that they're putting forth, under which they're applying for a project to implement. I'm not going to go over the rest of those requirements, but all of those have to be addressed in a comprehensive application for money for the implementation. The next slide, in terms of priority consideration, we do focus on programs in geographic areas where there is a disproportionate population of folks who are going to prison. We need to target higher risk individuals, and risk is determined by a validated risk needs assessment. You have to be able to clearly demonstrate the fact you've incorporated evidence-based strategies into your program. Certainly looking, as I mentioned earlier, for collaborative applications, which include input and involvement with nonprofit organizations, crime victims groups, so that the projects represent a collaborative effort of a broad base. Projects need to demonstrate effective case management. They need to provide for an independent evaluation and to highlight the swift, certain, and graduated sanctions. Those are things that we are looking for in terms of priority considerations. Now, what makes this particular solicitation different from previous two for 2009 and 2010 is the fact that there are two categories now. You can apply for a grant of up to $50,000 and we require 50% match. That would be a project of up to $100,000 for planning. This would allow a jurisdiction to work toward developing a strategic plan, making sure that they have the reentry task force in place, making sure that they have reached out to a collaboration of private nonprofits, and the money can be used to help them develop that. The idea of the grants are to be used to help action meet the 10 requirements that are outlined and articulated in the Chance Act. This slide, when it talks about Category 1, really just emphasizes the allowable uses of those funds. It can to continue or support the establishment of a task force, develop a strategic plan, begin to develop evidence-based methodologies, all those things that would put an applicant agency in the position of being able to develop a full-grown and acceptable chance application for the actual implementation of a project. We, however, guarantee that after the planning process that there would be money to fund the project, but certainly this would allow an organization to develop a strong application that, if funding is available, that hopefully would give them sort of a step up on getting it. What the grantees will receive under the planning grants, you won't actually receive a $50,000 check, but what you'll receive is targeted technical assistance, our groups working with you for a period of a year to help you be able to develop that plan. The criteria, this is the next slide for Category 1. The statement of the problem is 20% of that. The next slide talks about the project design and implementation, which is 35%. And this would be the activities that you would propose to undertake using technical assistance under the grant to allow you to meet those 10 requirements that would be required for an implementation grant. It would count for 35%. Capabilities and competencies. This talks about how the collaborative structure of the project would be set up to facilitate planning. Again, identifying the various stakeholders and their roles, who the consumers are going to be, what your target population would be, and provide a timeline and project potential barriers to the implementation of a project if implementation money were available. And that's an account for 20%. In terms of the impact, outcomes, and evaluation and sustainability, this would be being able to talk about how, if you were able to develop a sound plan and get funding for an implementation project, how you might propose to continue that project, and that would be 50% of that. Performance measures, the slide, basically just indicators of the number of people that you've been able to get to involve, the number of planning meetings. They're really particular data points that would indicate progress in the planning process. Now, category 2, which is the next slide, this is identical to the solicitations that were posted in 2009 and 2010. We're getting grants of up to $750,000 for a 12-month period. This slide talks about the allowable uses for the funds. Basically, what we're looking for are comprehensive reentry projects that start pre-release, where a target population of offenders, generally these would be medium to high risk offenders who are currently incarcerated in a prison or jail, where an actuarial instrument is used to assess their risk and needs, providing treatment interventions that target criminogenic needs, as well as providing sustained case planning and case management services on a pre-release basis, and all after the person is released and reenters society. The funds can be used to provide a variety of supportive services. They could be used to pay for substance abuse treatment. They could be used to pay for mental health treatment. They could actually be used to support housing by subsidizing rent, or support employment by subsidizing wages. Although we are very reluctant to encourage that, because subsidizing wages and housing eats up money at a very rapid pace. But the bottom line is that this grant money can be used for anything that would support and help to ensure the successful reentry of a person back into the community. Family counseling, as I said, substance abuse, mental health treatment. The next slide talks about the selection criteria, and they're very much the same as the other. The statement of the problem is 10%. Project design and implementation, how you propose to structure your project, and the timelines for implementation, 30%. The organization's capabilities and competencies. How well can you demonstrate to the peer reviewers that you are able to do what you say you want to do if you get the money? Impact outcomes, 15%. The degree to which your application reflects that collaborative effort I talked about earlier, the degree to which the application folds in private nonprofits, faith-based organizations, and other government agencies to take a very collaborative approach. That's going to represent 10%. And then the fact that you propose a cost-effective and sound budget is 10%. The next slides that Leah is going to go through talks about the selection criteria in more detail. The first slide gives you some bullet points about that would be looked for in the statement of the problem. Second slide for category 2 talks about project design and implementation, which is 30%, what the peer reviewers will look for. The next slide, implementation projects, selection criteria, which is 25%, again, what the peer reviewers will be looking for. Same is true for the next slide, which is on implementation of the implementation and outcome strategies. And then we'll talk about the performance measures. I'm not going to go over these. They are, again, detailed not only in solicitation, but also in these PowerPoint slides, which will be available to you online. The bottom line is that we are looking for those data points which indicate an overall reduction in recidivism. We are requiring that with the target population that you identify to be the subject of your project, that you are able to identify a baseline recidivism rate. The various pieces of information that are required here In your application, you would just simply need to verify that you have the capability to collect and maintain and report this data. If you're fortunate enough to be given a grant, then the data will be reported through our our performance-based reporting system, and it will all be done online, and you will be given further instructions. Collection 10%. As we mentioned earlier, the budget is low, 10% of the total score. Category 1 awards are up to $750,000. Category 2 up to $50,000. The next slide talks about the match requirement. Unfortunately, for Section 101 of the Second Chance Act, there is a 50% match requirement, which means if you get $100,000 of federal money, you have to come up with $100,000 of match. 5% of that match, or in the case of a $100,000 grant, $50,000 of that would need to be new hard cash, and then $1,000 would be in the form of in-kind match. Because the 2011 budget is continuing resolution is based on the 2010, we have language that Congress put in the 2010 budget, which allows jurisdictions who are under severe fiscal hardship to request a waiver of the 25% cash match. You cannot come up with a 25% new hard cash match. You need to send a letter in with your application simply requesting that the cash match be waived. And in most cases, we will waive that cash match. We'll take your word for the fact that you're under a severe fiscal hardship. But you will still be required to put up a 50% in-kind match. So if you request for a waiver of the 25% hard cash, it would mean a full 50% of in-kind match. Next slide talks about the match waiver. And of course, again, if you want to go back and refer to that once the slide deck is done. The next slide just simply has contact information. There, as Leah pointed out, there's a support line for grants.gov. You need to read the solicitation carefully and understand that you have a DUNS number and a CCR number. You have to register with grants.gov, and you should start this process at least 3 to 4 days prior to the submission deadline. Because if you don't have your CCR number, if you don't get your DUNS number, or if you wait until the 11th hour to start inputting this application into the grants.gov system and you're into a technical problem, the chances are there's not going to be enough time to resolve it. So even though the deadline may say midnight on, I think it's June 30th, you should start well in advance. If at this webinar and the questions that are posed and answered, the Research Center will post a FAQ, frequently asked questions document that you can refer to, but you can also get information and answers to questions at the Justice Information Center. In this particular slide, there is an 800 number where you can reach them, and also an email address. So if any questions come up after the webinar that aren't answered by the FAQs, then you can get information on the solicitation through the Justice Information Center. I know that I've gone through these slides very hurriedly. I hope what I have said has been reasonably coherent. Leah has done an excellent job of advancing the slides for me. As she indicated, these slides will be available online for you to print out or to refer to. We will now open up the floor for questions. The questions that are asked and answered during this webinar will be added to the FAQs so that they'll also be available online. So Leah, I'm a bit out of breath right now, so I think I'm going to turn it over to you while I catch my breath and see if there are any questions.
We've got a few questions that have come in. If there are other questions out there, please make sure to type them into the Q&A box that appears it should appear in the lower right-hand corner of your computer screen. Let me start with one question we've gotten from quite a few folks is from grantees who were awarded demonstration grants or some other kind of second chance grant in either 2009 or 2010. How does that grant impact their application here? Are they eligible to apply? Is this for continuation funding, or are they able to apply for new projects?
Because of the restrictions in the funding for our Second Chance Act, the grant awards, if we have any 2009 demonstration grantees. We'll be contacting those 2009 grantees. Of the 15 that we're awarded, 8 of those will be given non-compete continuing funding as a result of their selection. One of the decisions is to participate in an NIJ evaluation. We will notify you shortly about which ones are going to get that. Any other 2009 grantees, either mentoring grantees or any of the other demonstration grants that are not going to receive non-compete funding, are eligible and welcome to apply under this solicitation. Excuse me, not the 2009 mentoring grants, because the 2011 mentoring solicitation has already closed. Those folks who received 2010 demonstration grants, there will be no non-compete funding. So if you are interested in continuing your program, you are eligible and you should apply under this 2011 demonstration solicitation for money to continue your project. But keep in mind, it will be on a competitive basis with everyone who applies. But yes, folks who have already received demonstration grants are eligible to apply and should apply to use money to continue their projects.
Ari, with regard to the match, the 50% match applies to both the planning and the demonstration grants, right?
That's correct.
Okay.
And waiver also applies. So if a jurisdiction cannot come up with 25% hard cash for a planning grant, then they can ask for a waiver, and in all probability it will be granted.
Few questions from folks who are wondering about whether or not they should apply with a program that has been around and up and running for a few years, or whether they should be applying for a brand new program that they're just putting together now for the purpose of the solicitation. Do you have any suggestions about that?
I believe that it doesn't matter. I think that we are always looking for new and innovative projects, but certainly because we have made this solicitation available to folks who received either a 2009 or a 2010 second chance grant as a continuation vehicle, then I would think if someone had a really good entry program that they had been supporting for several years and the funding was beginning to run out at the state level, I think you'd have to be careful to not supplant that. But if you wanted to expand that program maybe to another site, that would be an acceptable target for an application. The problem is you avoid supplanting, which means that federal money is used to continue something that's already been funded with state money. So if it were expansion of that particular project, then that would probably be all right. In the case of the 2009 and the 2010 projects that were funded with SCA, we're talking about, in most cases, not supplanting, but adding to federal money that has already been awarded.
Gary, can you talk about the relationship between the Category 1 grant, the planning grant, and the Category 2 implementation grant? If a grantee has not previously applied for a Category 1 grant, will that have any impact on their eligibility for Category 2?
No, it will not. If they feel like that they have done sufficient work in their jurisdiction, and by that I mean they've had a reentry task force in place, they have a strategic plan, they can clearly demonstrate how the members of that reentry task force and other stakeholders like the victims community have had input into the development of that plan. If they're able to cite evidence-based practices that they intend to use, if they're committed to six principles and strategies of evidence-based practice, including using validated needs assessment instruments. In essence, if they feel like they're able to make a strong case how their application meets all 10 of the mandatory requirements for a demonstration project that actually are part of the law, then they go directly for money, the $750,000, to implement their project. The planning grants are really for those jurisdictions that need help getting started. The unfortunate situation is that because of what appear to be some severe budget constraints in 2012, there really is no guarantee that someone who gets a grant 2011 this year, goes through a full process, develops a great project plan and application, that we'll have enough money to actually fund an implementation project in 2012. So if you feel like that you can put together an application that meets all 10 of those requirements for implementation money, that is probably the way to go.
We've a few questions from folks just asking us to clarify what folks will get if they receive a planning grant. So they'll receive a $50,000 grant for BJA, right? And they'll also receive some specialized training and technical assistance on top of that, with the intention of helping them prepare to implement their projects at the end of their planning stage.
That's true. And earlier I did misspeak. The $1,000 will actually be a grant, and you will have to propose a budget on how you're going to allocate that money. There might be a portion of that could be for someone to coordinate the planning process, staff person. A portion of it might go to cover meetings, expenses related to meetings of a task force or pulling a task force together. So in addition to the money and the budget that you put together, some of that money could also go for more specialized consultants, maybe to do some data analysis. But the Regional Reentry Resource Center will also provide technical assistance to help the folks get those grants implemented. But you're right, there will be actually $50,000 of money that will be available to the site, and that award would be sent based on the budget that is submitted with grant application, in addition to the targeted technical assistance. So the line is that people who get a planning grant get money and technical assistance.
Gary, I had a few questions about eligible uses for grant funds, specifically with regard to the implementation grants, from folks wondering if they can use those funds to hire staff, to contract with a nonprofit organization. Can you give folks some senses of what they're able to include in their budget for those implementation grants?
Yes, I think the answer is yes. Certainly, you can hire staff if you need full-time staff. That's an allowable expense. Contracting with a private nonprofit or faith-based organization to provide services in the community. Let's say, for instance, there's a private nonprofit that has an excellent reputation for providing drug treatment services. You could, in accordance with the procurement procedures of the government agency, you could subcontract with them. So the one thing about the Second Chance 101 money is those funds can be used just about any service to either provide or buy that is going to significantly enhance the likelihood that a person is going to successfully reenter society. So contracts with private nonprofits, hiring full or part-time staff, providing some level of support individually, whether it might be rent subsidy or employment subsidy, all of those things are allowable expenses. But the only thing that these funds will not support are type of bricks and mortar construction or major renovation or the purchase of large items of equipment. For instance, you couldn't buy a car for an offender who's coming out.
I've just gotten a couple of questions while you've been answering that question. Can it be used to help pay for doing or implementing a specific assessment tool?
Yes, it could be. There are so many, like the SIR and the Compass. There are a lot of tools out there where I'm afraid that inclusion of that in a budget might cause a peer reviewer to downgrade the budget, because there's no use reinventing the wheel. And if talking about developing a valid and validating an assessment instrument from scratch for a particular jurisdiction, that's a very expensive, time-consuming process. So I would say that I'd rather look toward using the money to purchase an existing instrument like the LSIR, Compass, or whatever, or if your particular jurisdiction Department of Corrections already has a validated instrument. So it would have to be very, very carefully worded and very tight if something like that were included in the budget. And I think I would probably encourage people to steer clear of that, but to look toward established instruments that are in the public domain or that could be easily paid for to be used.
How about training staff on evidence-based practices or or particular cognitive behavioral intervention? Can you pay to bring in folks to train your staff?
You can write that in under the consultants and contracts, and you can use that money to bring in consultants to train. Yes.
I've got a question about the priority consideration regarding independent evaluation. Do you have any suggestions for folks about should they be engaging a private evaluator for that? Is there anything anybody needs to know about the NIJ evaluation? Or independent evaluators have to use random assignment? We've had a few questions about the independent evaluation.
Well, this is a real tricky question because it does talk about priority consideration for it. Although we understand that flown random control trial experiments are very expensive. I think what we would encourage people to do is, number one, you need to make sure that you have a system developed to collect and maintain and report the basic performance metrics data. That's the first step and the most important one. If you are able to have an arrangement perhaps with a local university or a private evaluator for a reasonable amount of money to begin to do a process evaluation of your project or to make some projections, I would do that. But I'll be honest with you, anything other than being able to strongly the method for collecting and maintaining and reporting the performance metrics, anything else would sort of be icing on the cake. And if you're lucky enough to have a local evaluator who could provide the services at a reasonable price, yes, but would not devote a significant amount of my resources to evaluation, primarily because at some point in time, the National Institute of Justice may come in and pick up some of the evaluation responsibilities, and we would much rather see the bulk of this money be devoted to actually providing services to clients.
If you're in an agency that's interested in applying for multiple grants with multiple target populations, that might be interested in applying for either multiple planning grants or multiple implementation grants, what do you think about that?
Well, I think that any particular jurisdiction, let's say, I don't know, Aldisma County, Miami County, Florida, which may or may not be a county, I think you need to prioritize. Certainly, you would be welcome to put in multiple applications for various target populations, but I think the chances of getting more than one of those approved would be pretty slim. So if I were, my advice would be that to focus on a particular target population and a particular program design and sort of all your eggs in one basket, if you will, because I think it doesn't make a lot of sense to submit multiple applications because in essence you're really going to be competing with yourself. And if you were to get two applications that ended up being scored, that ended scoring high enough on the peer review to the fundable tier, I'm only going to fund one of those to the jurisdiction. You're not going to get both of them.
So that's for a single agency that might be interested in submitting several applications. What if you're in a city or a county and you know that your state has already received a demonstration grant? Will that have any impact on your eligibility?
Probably not, although it could enhance the quality of your application if you clearly demonstrate how the project that the city or county is applying for is going to supplement or augment or leverage the resources that the state may have. In other words, if you could clearly indicate that you're collaborating with the state and that that you're asking for a particular city or county is going to be a way to leverage federal resources to get more money, and that you're collaborating at the state level, it could actually make for a stronger application and be a positive. It's not going to be a strike against you just because the state has received a demonstration grant or any other type of second chance grant in the past. It's going to react poorly on the local jurisdiction. So
at this point, I want to put a plug in for something that's available on the National Reentry Resource Center's website, which is our map of national criminal justice initiatives. If you're in a city or a county or a state government for that matter, and you're not sure which other entities in your region have received Second Chance Act grants in previous years, we have a map that lists of the 2009 and 2010 Second Chance grantees, as well as grantees from a whole host of other federal funding streams that have funded reentry initiatives. So if you're wondering what other jurisdictions in your area have received from the Second Chance Act, please take a look at the map so that you can get a sense of that. Gary, you have a sense of how many grants will be awarded under this solicitation?
I honestly do not, because we have not, the money that was appropriated for this particular session, there are several. We have to provide continuation funding for the National Reentry Research Center. There are other projects that have to be funded, so we really don't know. The one I can say is that last year, I believe in this particular section, we had a full $37 million, and we made something like 53 awards. The funding factor this year is the fact that we have the two categories, planning grants and demonstration grants. So a lot is going to depend on the volume that we have and how the peer review process turns out. I think there will be significantly fewer projects funded this year simply because we have less money.
Are there any restrictions on what folks can use as the source of their in-kind match?
And you have to be careful that the in-kind match doesn't represent supplanting. You have to make sure that federal money cannot, any type of federal money cannot be used to match other federal money. And what is supplanting, if it was a vacant position was funded with, let's say, state or local dollars, and you're going to use that position to be the project coordinator, that would count, the salary and fringe benefits would count as match as long as that position was vacant. If the state or the county had already been paying for a person in that job and you move that person over, then that would really just be supplanting. You would be using part of the project. Because it's match or federal money, once that's included, it all becomes part of the project. So the thing you really have to be careful is make sure that no federal money is used as match, and make sure that the match that you use is not supplanting some other previously funded project. Just as a tip, a lot of organizations are turning to the private sector. Since in the first round of funding in 2009, in New Hampshire, the New Hampshire Charitable Foundation actually put up the match for the State Department of Corrections grants. So I would certainly encourage units of local government and to some degree state governments to look to the private philanthropic sector for some help with the match.
We've got a question about the requirement that the target population must be individuals who have been convicted. If you're working in a county jail system where you're dealing with inmates with pretrial detainees, are limitations on using Second Chance Act funds to provide services to pretrial detainees, and do you have any suggestions for those folks?
Well, I really don't have any suggestions except to say that the chance money, because it's all about reentry, is tied to those people who have been either sentenced to do a term as a misdemeanor or whatever in a county jail, or who've been sentenced, obviously, at the state level. But it's not designed as a diversionary program. It's not designed for people who are on probation, nor is it designed for pretrial detainees, because these are people who've even been adjudicated guilty of an offense. And I just know that the second chance monies cannot be used to support those kinds of projects.
Do you have any suggestions for folks? We've got some questions from people who are in cities or counties and believe that there might be another entity submitting an application from the same area or for the same target population. Do you have any suggestions for those folks and who might be the right agency in a city or a county to submit an application under the Second Chance Act?
Well, it has to be, I assume that if it were at the county level, it would be either the office of the county executive, or perhaps if the sheriff runs the jail, it would be the sheriff. Of course, at the state level, it should be probably the State Department of Corrections or whatever. So the only suggestion I would have would be that, number one, only recognized entities, government entities, can apply, and it should be pretty clear to see each of those agencies are qualified applicants. And for instance, if you suspected that the State Department of Corrections was going to apply for a demonstration grant but target a particular county, I think in the very first year, Florida Department of Corrections was the applicant agency, but they targeted Jacksonville, Duval County. But there's a collaborative arrangement between the two. So if you feel like that there's somebody else in the area, you ought to certainly contact the agencies that are eligible to apply, find out if they are intending to, and the course of action, in my opinion, would be then to collaborate and go in together as opposed to submit competing applications.
If you're a city or a county that's in sort of the opposite position and that you'd like to work with individuals who are coming out of the state corrections system, is there anything additional that you need to do in your application to demonstrate your relationship with the state corrections department?
I think that certainly talking about how you would provide or build on pre-release services that the State Department of Corrections was providing. For instance, I would assume that if it's a progressive state, they would have done the risk and needs assessment so that they would be able to work with you and provide you that information to help you zero in on your target population. But at minimum, there'd be a letter from the Commissioner or Director of Corrections of support for the project with the assurance that the people from either the city or the county or the private nonprofits that were involved through a collaborative effort with the city or the county would access pre-release access to the target population. So short answer is just simply documentation from the State Department of Corrections that they are willing to collaborate and that they're willing to cooperate by providing information on the target population as well as access to be able to provide pre-release services.
So we talked a little earlier about allowable uses for Category 2 funds, and we've since received some questions about allowable uses for Category 1 funds for the planning projects. Can folks use the planning funds to either hire or train corrections or parole staff?
No. Those funds could be used to hire consultants to help with the planning process, but they're not designed to be used to support actual program services. Now, let's say, for instance, if you have a task force, you've appointed a reentry task force, and you wanted to bring a consultant in to do orientation or training with that reentry task force to help improve their ability to work together, group building, team building, or whatever, that could be a legitimate function. Just using that planning money to train probation or parole staff would not be an allowable use, because it really is the implementation of a program and not planning for a program.
Okay, I'm doing my best to keep up with this Q&A box. It's been very busy. I've got just a few more questions, but I just want to let people know if you'd like to submit a question and you haven't already, please make sure to submit it through the Q&A box, and we'll get to it before we finish the webinar today. Gary, how about incentives for individual program participants? So if you're running a planning to implementation project, can you use grant dollars or matching dollars to provide some sort of incentive to the offenders who are participating in your program?
You can. For instance, you can provide gas cards, or if need be, if on a short-term basis, if someone you might be able to provide some type of access to food. I would just ensure that any incentive can be clearly tied back again to supporting the person reentry efforts, and absolutely would discourage the use of any type of cash incentives. Oftentimes a gas card, not a gift certificate, but a food voucher or something like that. But yes, they're under appropriate and clearly articulated connections to helping an offender successfully reenter, the money can be used for incentives.
Okay. I know we talked about this before we a couple of questions since then, though. So we want to be clear that for those folks who apply for a planning grant this year, there's no guarantee that an implementation grant will be available next year.
It's going to depend entirely upon our appropriations. If we get a significant appropriation in 2012, I think it goes without saying that those planning grant applicants who develop a good model application and program would certainly be given priority consideration for implementation funding, but it will really depend solely on the availability of resources.
You're submitting an application from an agency that works very closely with another agency. So maybe you're a county and you work very closely with a city. Can you submit a joint application between two entities, or does one agency need to take the lead on the application?
One agency needs to take the lead on the application. So one agency would be the applicant agency. The grant would actually be awarded to them, and they would be the fiscal agent. But there's significant flexibility in terms of subcontracting and working with another agency based on the local procurement. And it could mean that if a city and county were working together and the county was the lead and applicant agency, then there might be a mechanism through an interagency agreement to simply transfer funds. But there has to be one applicant and one person who is the responsible fiscal agent.
Okay, so I talked just a few minutes ago about counties who might be interested in working with a state prison population, and we've received some questions about corrections folks at the state level who have individuals incarcerated in local jails. Can the state DOC apply for funding to provide reentry services to individuals incarcerated in local jails?
Yes.
Okay. Workforce investment boards eligible applicants?
No, I don't think so. Let me back up and not be so adamant about that. I'm not really sure if the Workforce Investment Board could be the case that they are clearly a government agency, then yes. But from what I know, and I don't know as much as I should about the organization and work of the we as the Workforce Investment Boards, I will say that it would be better for there to be a collective effort and for either a county government or state government or city government to be the applicant agency. But it would depend on the ability of the Workforce Investment Board to make a case that they are truly a government agency.
Can grant funds be used to pay for transitional housing units if you're not using that money to build the transitional housing units?
I assume that means to subsidizing rent or whatever, but yes, let's just simply say that the monies can be used to pay for transitional housing.
I am at the end of my Q&A queue. There are a few questions that we didn't get to. I'm not missing anybody. If we skipped over your question, it's just because either, frankly, because I missed it or because it was answered previously. So I'm going to give everyone my contact information so that if you have a question that you don't feel like we've addressed here, please feel free to contact me and I might be able to answer it for you. My telephone number is 240-482-8585 and my email address is lkane@csg.org. I've also put back up on the screen the contact information for both the grants.gov consumer support line as well as the Justice Information Center, which provides you information about different aspects of the grant application process. Gary, any last words?
I just appreciate everybody's attention. I hope that this webinar has been helpful. We are very proud of our Second Chance Act work. We were pleased that we're going to be able to at least make a few more awards this year. And we're also very interested to see how this category of planning grants works. We have asked Congress is currently working on a reauthorization bill for the Second Chance Act, and one of the things that we've asked them to consider is a modification of the Act itself, which will allow for the progression of planning to implementation to enhancement grants, much like we've done with the mentally ill offender program. But I would encourage people to, nothing ventured, nothing gained, to put an application. Again, encourage folks to be as collaborative as possible, as creative as possible, and to really emphasize their willingness and ability to use evidence-based practices. And we certainly wish folks luck. We didn't really talk a lot about our review process, but since we're just a little bit of time, I will say that all of these applications are peer-reviewed. And for you who don't know how that works, generally we have panels of 3 peer reviewers who have experience in corrections backgrounds, hopefully in some type of community corrections or reentry. Each panel is assigned 15 applications to read and score, so that the 3 people read and score the same applications. Their scoring is based on a sheet that is developed from the criteria that we talked about in illustration, as well as it's outlined in the slides. And so once applications are scored, if there's a major division among the 3 people on the panel, we have a census call. After all of the panels have reviewed all the applications, then they're all put together and funding tiers are established. So it's a very, very fair process. It's a process based on reading the quality of the application and how well the people have met the requirements. So the last word would be just read and reread the solicitation very carefully. Make sure that if you're applying for an implementation grant, the full $750,000 grant, that you clearly address all 10 of those mandatory requirements. And certainly don't be afraid to ask for help. And the last I would say is that make sure that you start very early in the submission process, at least 3 to 4 days before the deadline, because invariably people run into problems and a lot of us get left out in the cold because of technical difficulties that just simply can't be resolved by the time the deadline comes around. Leah, thank you.
Great. Well, thank you, Dr. Dennis, for taking the time to lead this webinar today. Thanks to all of you out there who joined this webinar. We had over 100 folks logged in. Thank you for your attendance and participation. And we also want to thank the Bureau of Justice Assistance for sponsoring this webinar today. As I mentioned, a recording of the presentation will be available online very soon, and we'll email you when it's available. The slides themselves are already available on our website, and that link appears in the chat box on the right-hand side of your screen. Finally, when you leave this event today, a brief survey about the webinar will pop up on your screen, and we would very much appreciate any feedback you can give us. Thank you all.